Welcome to EB-5 Investment Voice, where attorney insights intersects with immigration investments. If you are a foreign investor, domestic fund manager, or enterprising entrepreneur and want to get the most out of the EB-5 program, you have come to the right place. I'm Mark Deal, and I'll be your co-host on this journey. I'm joined by your host, Mona Shah, and other attorneys at Mona Shah & Associates, as well as immigration leaders from around the world. So let's get into EB-5 Investment Voice. Mona, we are back and we are continuing our series of unfortunate events. And this time it is bankruptcy, not a delightful subject, but something we need to cover.
It is indeed, Mark. It isn't always fatal to be in bankruptcy, which is something that I really want to bring across to our listeners, because quite frankly, every time somebody hears the term bankruptcy, there is this knee-jerk kind of reaction and people do run away. There's lots of moving parts here. It's a difficult area, which we're hopefully trying to simplify. The bottom line is good representation with somebody who knows what they're doing.
Well, that sounds like a common theme for the last 7 years of this show, right? And that's why we're here, to educate people. And if they have the questions, well, they know who to contact. We also have a guest helping us with this serious topic of bankruptcy, right?
We do. And it's one of the best.
Well, of course, it's one of the best. I mean, we've been around for so long, we only get the best. And that's why we have Joseph Moldovan. Joe is a partner at Morrison Cohen LLP and is the chair of their business solutions, restructuring, and governance practice at Morrison Cohen. He leads a team consisting of veteran bankruptcy, which, of course, makes him the perfect guest for today's topic, corporate finance, litigation, benefits, and tax professionals. Joe, welcome to EB-5 Investment Voice.
Hi, Mark and Mona, and thank you very much for inviting me to this podcast.
Well, thank you so much, Joe, for coming on. There are very few people who even understand what EB-5 is, let alone manage EB-5 in bankruptcy. Joe, let me ask you, the term bankruptcy really frightens investors, and I'll tell you why. In most countries, bankruptcies really mean complete liquidation, what we call Chapter 7s.
I think that's right. The vast majority of the world still looks at companies that are in distress or companies that are in trouble as targets to be liquidated. That is not the case in the United States. The U.S. has had a uniform law on bankruptcy since the 1800s. The right to bankruptcy is enshrined in our Constitution. And basically, the concept of bankruptcy in the United States is very consistent with other U.S. and American traditions, which is the right of a second chance. And that's what the U.S. Bankruptcy Code does. It gives companies a second chance. And with that, it gives the company's creditors a second chance.
That's really important in EB-5 because hopefully, eventually we'll get through to the government and explain that, in business circumstances, things happen. But we do have time in EB-5. It's not like everything has to happen straight away. But here's the issue, Joe. As we are seeing recently, and as you and I are actually working on projects which unfortunately are doing this restructuring, EB-5 projects are not immune from bankruptcy. That's because they're businesses.
Yes, that's 100% correct. I think what you have to begin with, in a sense, is understanding the dynamic of a bankruptcy case, of a U.S. bankruptcy case. And that is, it's designed to restructure indebtedness. EB-5 investors who invest in an entity, and by that they have an equity interest, that entity then invests and makes loans to some other entity. That gives those investors essentially, through this other entity, the status of creditors. And the bankruptcy code and the bankruptcy courts have very established procedures to make certain that the voices of creditors are heard and given the opportunity to influence how the bankruptcy case is conducted and have a stake and a say in their recovery.
That's very interesting, Joe, and I'm going to come back to that in a second. The first thing, though, I'm going to ask you is that if I was just an investor, for example, in a project, and it was going through Chapter 11 bankruptcy, all I wanted was my money back. It's easy. It's just, there's one thing that we want to do is just be able to get a return of our capital. However, for EB-5, we need something more. We need that project to be completed in order to count the jobs, in order to be able to get our green card. What do we do, or what would a client do if a project is going through Chapter 11? Is there a way to ask the bankruptcy court to just make sure the project's completed?
So the answer is, in a sense, yes, but it's sort of a greater question, and that is, since the idea of a U.S. bankruptcy proceeding in Chapter 11, as opposed to liquidation in Chapter 7, is to keep the business alive, the goal of every constituent, every party in the bankruptcy case is working to keep the business going. So while it is true, and this is, I think, where we have the distinction between the continuation of the business so as to enable the EB-5 participants to obtain the benefit of job creation and the business continuing from the repayment of the capital they invested. These are not necessarily the same thing, and they can actually occur together, or one may occur and not the other.
Joe, before we dive too deep into the various bankruptcies in the U.S., let's take a step back and paint a picture, or an example, if you will, of what bankruptcy means in a broad sense and at a corporate level, as well as how it might differ from what our listeners may be familiar with in other countries.
So let's begin with the following premise. When a company is in distress, the company can file for bankruptcy. Unlike in the rest of the world, or a large portion of the rest of the world, the company remains in charge. The board of the governance of that company remains in charge. Occasionally you have a trustee appointed. Occasionally you have a restructuring professional appointed. But basically the company remains in charge. And the company's goal is to create a plan of reorganization. And under that plan, the company intends to continue in business and to repay all of its debts. And then the debts get repaid in a very specific priority that is established under the bankruptcy code. For example, Mona, that priority is the first creditors who get paid in a bankruptcy are secured creditors. Those are the creditors who have liens on real estate, for example. They hold the mortgage.
Right.
Under U.S. law, they're entitled to get either the mortgage, they're either entitled to get paid, or they're entitled to their property. The next tranche of creditors are general unsecured creditors. And these folks who don't have a lien on collateral nevertheless have a right to be repaid. And they participate very vigorously in the bankruptcy process through two mechanisms. One is an official creditors committee, and two, through representation by their lawyers who make certain that their voices either individually or collectively are heard. And the bankruptcy court, which determines everything, listens to those voices to make certain that the rights of creditors are heard and respected.
That is very good to hear, Joe. So let me ask you, if there's a project which we know is going into Chapter 11 or Chapter 7, do you recommend that those investors seek out their own representative or go towards their regional center, or what do you recommend?
So one of the realities of life is, he who represents himself has a fool for a client. That is even more the case in a bankruptcy situation.
Right.
Bankruptcy is a regime established by a very rigid code and thousands of cases that have been decided under that code going back a very long time. Unless you, the creditor, are represented by someone who is familiar with that code and also familiar with the environment in which the bankruptcy is taking place, whether it's real estate or some kind of manufacturing, or in this instance, in the EB-5 world, that creditor is going to be massively disadvantaged because that creditor will not really know how to participate. If there's a regional center that is already representing that creditor, that regional center will be the focal point and will be the entity to speak on behalf of those creditors, those members in the bankruptcy case. So I think it's absolutely critical. I think one would be ill-advised to try to simply get on a court call or listen in to a hearing and think that one can participate. The answer is one really cannot or should not.
Yeah, I couldn't agree with you more. And I think, Mark, we often talk about going into, regional centers or groups where there is this kind of at least not only collective knowledge, but this ability to be able to handle situations which don't always turn out for the best, because that's life, isn't it? We aren't always going to have a project, or a regional center which has multiple projects isn't always going to choose a project which works. There is going to be instances like this.
Right. And that's kind of the whole point of the series, is to hope for the best, but plan for the worst. And we're covering each and every one as fully as we can. Right.
Joe, I have a question for you, though. We have limited time in EB-5 in the sense that once the money has been put in, and once the case has been adjudicated for an EB-5 investor, they only have a limited time to create jobs. So if a project does go into the bankruptcy process, Chapter 11, for example, restructuring, does that delay the process?
No, Mona, it really should not. The beauty of the U.S. bankruptcy process is it's business as usual, supervised by a bankruptcy court, but it is business as usual. If there is a construction project that is in process, as long as that project has sufficient capital in order to finance it going forward, that project will continue. The project does not stop. It only would stop if money runs out. But that's not particularly a bankruptcy issue. That's an issue with any kind of construction project. So long as there's financing that can be made available to continue a project, bankruptcy does not stop it. In fact, bankruptcy can enhance the ability of the project to be completed, because bankruptcy stops all lawsuits against the company. Anything that might distract the company from proceeding is going to be stayed under what's called the automatic stay of the bankruptcy code. So no, Mona, a regular Chapter 11 case with adequate financing will not delay the EB-5 process or the EB-5 investors from realizing what they want.
That's really good to hear. I'll tell you why. Because if, for example, it's a building, we know it's being built, at least we know that the jobs have been created and the investors do get their green card. Now, the next big question, actually, by the way, with regards to that, this is something which has been established for quite some period of time. Quite some years ago, back in 2014, our firm was one of the firms involved with a bankrupt project in South Dakota, the meat marketing factory. And that was one of the cases, one of the landmark cases that USCIS did decide for the investors, even though the project had gone bankrupt and they went into a Chapter 7, not a Chapter 11 bankruptcy, but enough jobs had been created for almost everybody to have got their green cards. So, but the other big question that I'm going to have for you is, it's not guaranteed. Of course, there's no guarantee, but a Chapter 11, will that mean that an investor will get their money back, or does it really depend where they stand?
So, Mona, perhaps you can help me out, because I've learned under your tutelage quite a bit about the EB-5 process. But perhaps if you just give me a little bit of a lead-in as to how the investors actually invest and what's the money flow, I'm happy to give you the answer about where they stand in terms of being repaid.
Okay. Well, most investors in these type of projects there's a division. There's either what's called a direct project or a direct pooled project, which is no longer available, or a regional center project. So if we take a regional center project, investors will invest in an entity, and that entity will either be will either have preferred equity in the project, or it will give a loan to the project. So either way, it'll either be a creditor or it'll be an equity holder.
Okay, so I think it's very important to understand that we have a hierarchy in terms of payment under the bankruptcy code, and this is pretty much inviolate. And the hierarchy is secured creditors get paid first, equity holders, meaning someone who holds actual equity in the debtor. And normally that equity holder might be the original sponsor, let's say, okay, or a private equity firm. That equity gets paid last. But because it's my understanding, most EB-5 investment is done through a vehicle whereby the EB-5 investor having its capital at risk in an entity, that entity then loans the EB-5 investor money by way of some form of debt instrument into the borrower entity. In the hierarchy, they then essentially are second as unsecured creditors as opposed to equity holders. And again, the way it works is you simply tick off down the line. You pay one class of creditors in full, then you go to the next class, and the next, and that's how payment is determined. But so long as the EB-5 investors are putting their money in to an entity that makes a loan, they have as good a shot of getting that money repaid as any other creditor.
What about EB-5 investors who go into a project as common equity and not preferred equity?
So EB-5 investors who actually own common interests in the debtor entity unfortunately, are at the bottom of the chain and will only get paid on account of their equity investment if all other creditors are paid in full or agree to some different kind of treatment. If you take a look at any of the larger bankruptcies that have occurred in recent times, you will see that what typically happens to owners, equity holders or owners, is that they are wiped out. The creditors who hold debt instruments get something back. But if you're an actual equity holder, your financial interest is wiped out. Now, that is not the same as, you will, I'm sure, make clear to everyone the other side of this coin, which is the ability to obtain the green card based upon the creation of necessary jobs. They're not related in terms of the bankruptcy process.
Joe, you're absolutely right. But here's the thing. If you come in as common equity, the interest rate is so much higher. I see a lot of investors who are really tempted in a project. And we've discussed this many times about interest rates, but it really boils down to it, really, doesn't it? That the higher the interest rate, the more the risk.
I'm a restructuring lawyer. I live my life in the finance world. And the reality is, if a lender makes a secured loan and takes as its collateral a nice piece of real estate, the lender's not going to make a lot of money on interest. It can make a market rate of interest, and that is somewhat dependent upon, market forces. The next level is typically mezzanine debt. Mezzanine debt, having a much higher risk profile because it's not secured by anything, gets a higher coupon, let's say 12%, 9%, 12%, even 15%. Equity is completely at risk. So you're right. A equity holder can hope to get a much higher rate of return. I think as a lawyer, I am philosophically very, very conservative. Not necessarily politically, but I'm very conservative when it comes to investment opportunities and things like that. I am very risk adverse. Personally, I think equity is for people who have the ability to take those risks. And if they take those risks, they can realize great returns. But as the stock market is a perfect example, you can also not get great returns and you can lose a lot.
But the trouble is, so many EB-5 projects are structured around equity, preferred equity, and not a loan, where you can collateralize a loan, but you can't collateralize preferred equity.
That's 100% correct. You cannot. So you have to go into those types of investments understanding the risk profile of the investment. Not all equity investments are at great risk. It depends upon the business. Normally, a nice piece of real estate is going to be let's just say a slightly better investment than a brand new shiny internet company, which has no real assets behind it.
There are factors, Joe. I mean, you've done enough of these. There are
Yes.
factors to see that sometimes a mile away you can see trouble, or you can smell trouble, or you can be suspicious. And it may not be because of the industry. It may just be because management is suspect, or location of the project is a little dicey.
I think that's right. And I think as an equity investor, you have to be much more knowledgeable and much more proactive in terms of the interest you take in the entity. If you have debt, that debt's going to trade at a particular level, or it's going to get repaid in whole or in part with a interest coupon. If you have equity, you really need to drill down into who the management is of the entity, the nature of the business, what kind of debt is on top of you. You have to know all of these things to be an equity player.
You know, you have a very good insight onto the market. And as we hit a recession, already we're seeing so higher interest rates. It's always this particular period of time in which developers do look for EB-5 capital. Do you have any advice at this point for our investors? I know it's very difficult for me to say that, but
typically when clients come to us in these kinds of situations, we simply identify for them that our recommendation would be to take some kind of a debt instrument, even if it is subordinated debt, even if it is debt below other debt. So long as you can get some kind of a loan in there, you're going to be better than equity. I personally don't take a lot of risk. Others certainly do. And it has to do with one's tolerance for risk. That's about the best that I can do. I can't say don't make the investment, because if you have additional capital that you can afford to risk, then by all means do it. However, if the capital that you're investing is capital that you really need to be returned to at some point, then as in any kind of financial professional will say to you, you should not take risk with that capital.
Yeah, good advice. Joe, does it make any difference that the EB-5 investor is not a U.S. citizen or green card holder? That they are probably, many of them, overseas?
Not in terms of the U.S. bankruptcy process. No, it doesn't.
It doesn't discriminate against a U.S. person against an overseas person.
No, not at all. If you're a creditor, and you have a right to be paid by the company. The key is, what's the entity? Is the entity a domestic entity or foreign entity? The U.S. Bankruptcy Code can cover both domestic and foreign entities. It can cover both U.S. citizens and non-U.S. citizens. This is financial. I mean, that's all that's going on here. If the company owes someone money, the bankruptcy process is designed to provide a mechanism whereby that money can be returned to that party.
And Joe, how transparent is it for investors? I mean, is there a method, or there's a portal that they can see what's going on in the process?
Yes. So one of the other incredibly great things about the Bankruptcy Code, with the wonders of the internet, is that the bankruptcy process is pretty much 100% transparent. And what that means is, first of all, every single filing in a bankruptcy case is on the internet. And it's usually on a portal, if the case is big enough, that is available to anybody to look at any time. If the case is a smaller case, you may have to go through what's called the United States PACER system, which is a public system, but you have to register for it. Otherwise, you have complete access to any document that's filed in the bankruptcy case. Also, of course, like every other U.S. court proceeding, bankruptcy cases occur in an open courtroom where anybody can come and listen. During the COVID period, most bankruptcy cases in courts, most bankruptcy cases were conducted virtually, and anyone could log in, listen, and even participate if they so chose. Again,
I know that happened recently on a case, on an EB-5 project, and there were so many people. I think the Zoom room was just completely full.
Yes, it sort of like broke the Zoom.
Yeah.
The number of EB-5 folks broke the Zoom, and that was just to listen. They weren't really even asking to say anything, but the Zoom was incapable of handling the number of folks that wanted to hear. One of the things, obviously, the lawyers do, and lawyers can do, and can do better than individuals, is participate in those hearings on behalf of either one investor, multiple investors, a regional center, etc., and then report back. Because even though you can listen, that doesn't mean that everything is going to be simple to understand. We do have our own language. We do talk in terms of the code. It's important to have it properly translated so that the investors can be adequately and properly informed.
You know, Joe, I've been doing a lot of research on bankruptcy and EB-5 lately, and I have come across a lot of projects, some which have been publicized by, in business journals and stuff, and some through just, investors or people that we have, clients that we have. What I have seen, though, is that not a lot of these projects do end up in Chapter 7s. They have stayed in Chapter 11, and they've been successful at the end.
I think that's correct. There is certainly the idea that many bankruptcies fail, but we're talking about a universe of bankruptcies that is inclusive of personal bankruptcies, small Chapter 11s, etc. The large commercial bankruptcy cases usually wind up either restructuring or they do wind up in an asset sale where the assets are sold to a buyer and that buyer continues the business. So in that context, the ability of creditors to get paid is significant and does continue.
Joe, so really what I'm hearing from you is that this opportunity for a second chance is not just there for the business, but it's also there for the investors. And it isn't completely fatal for a project to go into bankruptcy proceedings.
I think that's completely correct. It is not fatal for a company to go into bankruptcy. There is an opportunity in the bankruptcy process to enable the company to succeed, to enable the company to have a fresh start, and to enable its creditors to recover. This is all part of the philosophy and purpose of the Bankruptcy Code. And I think that for EB-5 investors, they should not look at bankruptcy as a tragic consequence. Certainly it is something that must be managed properly. They must participate in it preferably for their own sake, through the use of competent counsel that is experienced both in the EB-5 area and in the bankruptcy area, and also preferably in the particular, let's say, the particular sector, such as real estate. And in that way, they can maximize their opportunity to get both repaid and to ensure the recovery of the obtaining of their green card.
Joe, that was perfect. There's nothing else that we could add to it. Thank you so much for coming on our show and explaining to us how bankruptcy can impact or possibly impact EB-5 investors.
It has been my pleasure. Thank you.
Thank you for being with us today on EB-5 Investment Voice. The topics presented in this podcast is informational in nature and is not to be taken as specific legal advice. If you have questions on the topics presented in this episode or other investment immigration needs, please contact Mona Shah & Associates. Mona and her attorney staff can be reached at mshawlaw.com. That's MSHAH law.com. Make sure you don't miss our next episode focusing on a different aspect of the EB-5 program by subscribing to the podcast. While you're at it, leave us a rating on iTunes. If you really found this episode valuable, share it with someone else that could benefit from this information. Until then, I'll see you on the next episode of EB-5 Investment Voice.